All right. Hello, everybody. Happy Friday. Thank you for joining us for our second webinar. If you tuned into our last webinar, you saw that we did leave off with a certain question leading us into cryptocurrency. So I did want to know, Dave, when somebody is estate planning with your firm, are they able to pay you in crypto? Is that a common question that
It's
you
a
get?
quite a personal question to start a Friday here.
Yeah.
Um, we're so excuse me. So we're not quite there yet. Most law firms have not gotten there because there is an important thing, and one of the benefits and also the challenges of crypto is that it is anonymous, and so we have to be able to account for who we accept money from and what the source of those funds are when we take on a client. That's our reasoning for not accepting crypto at this moment. There are probably firms that are accepting it, but at this point, we're not quite comfortable with it yet. So,
Okay.
but
Got it. Got it.
may have been a good move about 5 years ago.
Yeah.
So
Yeah.
yeah.
All right. And I do want to let everybody know this is an open forum. So if any questions do come to your mind, feel free to ask them as well. So we're going to go ahead and get started. We've got a couple preloaded questions here. So I know this isn't much of a financial webinar, but if you could give us a brief description of what cryptocurrency actually is, that'd be great for our viewers.
Yeah, absolutely. I'll go for a brief description here. I think it's one of those things where when you try to explain it, it can potentially become more and more confusing the more detail we add to it. So the way that we explain it to clients and potentially, to clients' families is it's another form of currency that has financial value. There are things that people will talk about in crypto world. They'll talk about it being decentralized. They'll talk about it being encrypted. They'll talk about blockchain, and they'll talk about the different coins. So we have Bitcoin, Ethereum, Dogecoin is still out there and actually doing fine. But there's like hundreds of different coins, right? And so you can get really lost in the weeds. I think the key thing here is that it's another form of currency. So just like if someone was leaving a bank account in the US with $100,000 they're leaving that to their family, and then they had another bank account in the UK and they're leaving 100,000 pounds to their family. We have two forms of currency, but we are still disposing of them through our estate planning documents. And so, eventually I think crypto will be regarded the same way. But right now, people are widely still trying to understand it, and so it's really, really important to keep it at a very, very high level, and just think of it as, this is just another form of currency. It has a digital aspect to it, decentralized, all of the other things that I talked about. But let's just focus on it as another form of currency that has monetary value.
Awesome. All right, got it, got it. So that takes us into, one of the main questions that I had. Is cryptocurrency pretty common these days in modern, I say modern estate planning because, the world's moving forward.
Mhm.
So is it, pretty common amongst your clients or people that you've heard of who are interested in estate planning? How common is it?
Yeah, great question. It's increasingly common, for sure. I would say that, say 3 years ago, we weren't having maybe any conversations about crypto, and as of this year, we have that conversation with maybe one out of every 10 clients that we work with. I will say that I have that conversations about crypto with a lot more folks, just that I interact with on a day-to-day basis. So it could be my barber, it could be, other folks that you're, chatting with at a restaurant. So it's becoming much more widely adopted, and I think a lot more people outside of the financial sector who are, kind of the pioneers, or, on the frontier of this. It's outside of that that bubble, but a lot more people are diving into this, or at least dipping their toe in the water, and they want to talk about it, they want to explore it, and very often they've actually put their money behind it as well. So we certainly anticipate that this is going to be an ongoing increasing category of asset that we need to plan for.
Got it, got it. And I do assume that, you and your firm is moving in a direction to account for those changes and for planning in the crypto world.
Absolutely, yeah. You have to, and it's in the same way that I think when we think about other asset classes, right? I think as so we've been around since 2012. I've been practicing since 2009. I think just looking at changes in the real estate market during that period, and where people have invested their money and changed the way that they invest and things like that. Our job as estate planning attorneys and estate planning professionals is not just to be responsive or reactive to what the client brings, but also to keep an eye on and have a pulse on the things that excuse me, that are affecting our clients' planning, and some of the considerations that they have as they build their net worth and think about how they're going to plan for their family, for the next generation. So when we think of crypto, Bitcoin, these other coins, this whole space, really, this is really an emerging asset class. For many people, it's already emerged. They regard it as very solid and reliable. For others, it's a little, it's a bit newer and a bit riskier. So people are still becoming comfortable with it. But generally, this is what we would think of as an emerging asset class that we need to be aware of. There's NFTs as well, which are non-fungible tokens, and we can get into that a little bit as well. But these are all new things, and when we have these conversations with say many of our clients, they may be not as aware, but there is a category of our client that does expect us to be well versed in these things, and that benefits all of our clients.
Yeah, I can imagine. And I'm sure for your clients as well, a lot of them probably are also unfamiliar with this field, or, they own cryptocurrency, but then themselves can't, define it for themselves, or they lean to you, to explain a lot of this. So I imagine it could be a really confusing world.
Yeah, absolutely. I mean, and in the same way that I think, for many of our clients who own securities, or don't, right? For maybe the clients that don't own a lot, they don't play in the financial markets, or they don't own stock or options, or they're not in that world. This would also feel similarly confusing. It's just another area where there's just there's so much dialogue around it, a lot of information, and with information comes misinformation, and so it's just a lot of that going on. So our job is to keep it really, really, like I said, keep it really, really high level, and keep our clients organized in terms of the assets that they actually own, the actual crypto that they have acquired.
All right. Okay, got it, got it. So, from a planning standpoint, I know you said that, your firm is not quite there yet, but is moving in a direction to account for, cryptocurrency in a living trust. Would you mind going over, based on what you know, how you would go about moving, say, a cryptocurrency bank account? I don't know if that's the correct, you know, way to describe it, or an investment account that includes cryptocurrency. How would you go about putting that in a trust?
Got it. So two things on that question. So our firm, has definitely, with other estate planning firms that are at the forefront of this. Essentially, we have mechanisms for planning for this, and we have certainly planned for clients with cryptocurrency. What is lagging behind, and this is where there's a lot of development and potentially, a lot of activity, is the legal landscape around cryptocurrency. And so as we know, as as a firm that practices in the probate and estate planning world, we're talking about laws that are centuries, in the making, and have really become established through the course of many, many cases over centuries. And then we have, within each state, we have, our own court systems that govern, the administration of an estate within that state. And so we have the combination of that, plus we have decentralized currency, which is not necessarily tied to something like a bank account, right? So, and we'll get into how crypto is actually held. And so when we combine these factors, what we have is a legal system that is a pretty far away from catching up with the technology behind blockchain, cryptocurrency, etc. And so we as attorneys have to bridge that gap for this moment, until there is a well-worn pathway for how to administer these types of assets, which may or may never come. We just have to be honest with that. But in the meantime, we still have these assets, and there is a court system that we have, and we do have our probate codes for the states that we practice. And so there are still pathways to administer assets, even if the law hasn't necessarily has not necessarily been developed around that area yet. So what does all of that mean? There's really two pathways, and it's not different from planning for any estate planning client that we work with. The threshold question is, do we have assets that would justify the creation of a trust versus a simple will? Do we have assets that would justify the creation of a trust so we can avoid the probate process? Maybe there's family conflict that we want to address, or other factors. A lot of good reasons for creating a trust, which we go into from time to time. But essentially, is there a reason to create a structure? If not, and we're staying with a will, then we have to be mindful of the fact that a will has the potential to be probated, and anything that's probated, meaning going through probate court, is going to be part of the public record. So if someone owns Bitcoin, for example, or owns various cryptocurrency, a lot of the reason that people are getting into the space is privacy, and feeling that there's they have that anonymity in terms of the assets that they own, at least in the crypto space. And so if we have, on one hand, a will that has to go through court, which becomes public record, and then we have these assets that we want to keep anonymous and private, how do we bridge that gap? So number one, we would generally not recommend putting those assets or listing those assets out in the will, because that will become public record. And so that's number one. The way that we work around that is that we may have have the client prepare, and with the client, we would prepare a memo detailing the information, the access plan for the assets that are held, for the crypto assets. And I'll go into what that access plan could look like. But essentially, that would be separate from the will. So it's a separate document. And so not enter the probate court, would not enter the public record. That's if we go through the will pathway, which again, we don't recommend generally for a lot of other reasons. We want to avoid the court process, if possible. And we want to create a structure that has continuity, which is why we typically will go with a trust, whether it's a living trust or some other type of trust. So if we go the trust pathway, we now have a vehicle that we've created that by virtue of its creation, we have the ability to bypass the court. So we have privacy built in already. And we have a structure where we have someone to step in without court approval. All of this is without court approval. We have somebody to step into the driver's seat. We have a set of instructions, which is the roadmap, the trust document, saying that this is what we want to happen to the assets that are in the trunk. We want them to go to the people in the back seat who are the beneficiaries. We have all of that in place already. So what's missing is the information about crypto, which can be provided and put into, the trunk of the vehicle. So the big difference with crypto versus other assets is where is it held? So when we talk about something like a bank account, right? Typically if a client has a bank account, they want to put that account into their trust. They're gonna create their trust document. We'll have it executed. And then they'll take that trust document into the bank, and then they'll change the title to the bank account, and it will read John and Jane Doe, trustees of the John and Jane Doe Trust, dated, May 6th, 2022, right? And so that bank account now is linked to the trust vehicle that they have created, right? So that act of them changing the title has moved that bank account into the trunk of the vehicle. With crypto, what we have are digital wallets, and we have passcodes, and essentially there's a series of steps that would be needed to identify and provide access to. So it's kind of like gates that you have to jump through to get to the actual currency that you are trying to access, and whether that allows you then to transfer it or to liquidate those assets or whatever the case may be, pass them along to someone else. There are gates that have to be jumped through for that. And so many people that own crypto, they'll use platforms like Coinbase or Bitcoin, and these are platforms that are a little closer to having online banking, based, or like an online brokerage account, and so they're able to access there. And then those platforms may have their own protocol for this. And so Coinbase certainly does. Coinbase is one of those examples, and that they're probably the most popular. I think we could say that fairly easily. So the key thing is not so much to change the title of the Bitcoin or the crypto. You're not really doing that. What you're doing is providing access to the wallet by providing the information needed to access that wallet, and leaving that in a protected way for the people that need it at that time. So how do we do that? Right? So how do we actually get that access to those people and keep it protected? I mean, how many times have we changed our password and forgotten to update that? Right? These are some of the things, these are the challenges that we have with crypto, is that it's kind of, one of its best features is also one of its biggest detriments. By trying to maintain the privacy, we also jeopardize the ability to access it in the future. There's stories of crypto or wallets being lost, and with millions of dollars on it. There's a story of $500 million in crypto being inaccessible because there are no access codes or anything available. These are things that happen now, right? These are things that are happening now, and these are things that'll continue to happen, just like they do happen sometimes with other assets. Sometimes we have bank accounts in that we just never find out about for an estate that we're administering. These things can happen. They have a higher risk of happening in the cryptocurrency world. And so what we have to do is make sure with the client that we are capturing the required information to access the wallets and the cryptocurrency that they own, that they've acquired. So whether that's portal access to their Coinbase account or whatever the case may be, we need to make sure that that's documented. So that's a memorandum that will sit with the trust, or what we typically do is we'll incorporate that as part of the Schedule A, which is the last page of our trust that we typically create, and that's what lists out all the assets. We'll build that out a bit further, and we have and that provides the access instructions to the successor trustee, that backup driver who's going to take over at that time. The nice thing about that is that Schedule A's, that piece of the trust, is those are updated often. So clients will sell their home, buy another home, we update the Schedule A. No big deal. We don't have to amend the whole trust to do that. They'll close their bank account at Chase, they'll open one up at Wells Fargo, we update the Schedule A. No big deal. So crypto fits right into that, and we want to keep that. That's where we want, that information to live. That's the component that we use, that we've built out to bridge the gap between access and privacy when the time is needed. So, but it is important that we continue to have a conversation with our clients about, if you change an access code, if you change a password, if you change, something, if you've transferred a certain amount of currency, and now you own a different amount of currency, and that has different data associated with it, we want to make sure that that's all updated, as well. So otherwise, we run into the same failures that we would run into with another estate where we don't have complete information. So that's essentially the pathway that our firm and other firms are adopting, is it's a supplemental memorandum, various forms, but something that slots in to the existing trust document.
Got it. Got it. Well, thank you for that very detailed explanation. That actually crossed out, two of my questions I had coming up. So, that was
Excellent.
good. At this time, I would like to open it up to everybody else on the screen and see if there's any other questions that you guys have for Mr. Singh here.
I have a question. If a client were to add cryptocurrency into their will or their trust, would they be able to dictate if the beneficiary were to liquefy those assets, or if they were to have to keep investing them? Like, can they leave a set of rules essentially of how they would like the crypto to be used later on?
Great question. So this is an area where the law hasn't caught up with the technology yet. So while there are under the current law, essentially, if you leave a home to someone or a group of people, you can for a certain period of time require that home not be sold, or that it be available for the use of someone, or there are various exceptions, but you can't outright say this home is never to be sold. That's probably not going to be enforceable, but of course, smart lawyers have figured out how to work around that and maintain property within trusts for generations and generations. And we're all kind of familiar with the kind of the big family trust, the Rockefellers, the Gettys, et cetera, that we've heard of, that have maintained property over the course of many years. So so there are mechanisms to do that, and allow things to, or require that certain assets not be sold, or much simpler, require that assets be sold. That's something that is very commonly done, is to alleviate family conflict. Let's just sell everything, split up the proceeds, and get everybody to move on. That's much more common pathway. But if when we think about the family beach house, we think about the house that's been, or the ranch that's been in the family for generations, things like that. Those are things that typically clients will try to preserve over the course of generations. So the question is, do the laws that apply to something like real estate and that are state specific, do those laws apply to crypto, which is not even country specific? So we have that. That's an open question. I'm not aware of any case testing that yet. I think I think it's going to come down to, on something like that, it's probably going to come down to enforceability. If the successor trustee, the person who's in charge, and maybe that's a personal representative if there's only a will, if they did not follow the intentions of the person who passed away, what would be the consequence of that? And I imagine that that's an area where we could use the existing law, which has consequences for breaching that duty once you are in that role. Once you have, once you accept that role, you do have duties to the beneficiaries or the heirs, depending if it's a trust or a will. And so by looking at whether they have breached their duty by doing something different than what the document intends or communicates, does that create liability? Is that enforceable against that trustee or personal representative? I think it might be, I think it would probably go that way, but again, it hasn't been tested. And so, when we think about these things, I think these things will be attempted. It's so new. I mean, there may be many trusts at this point out there that attempt to do that. I own X amount of Bitcoin, never sell it, instead, continue to invest in Bitcoin, for the next 100 years, all of these things could be out there. A lot of this language could be floating around, but until it's tested, we don't really have any clear guidance. And then it's probably going to be tested in one state, and then we have to decide whether that applies to our state and how, what the wider application of that case will be. So.
All right. Any other questions from anybody else? All right. So, Dave, I see our time is coming to an end here. But I want to thank you, for giving us all the knowledge about cryptocurrency. We will be coming with you with cash if we need a trust for now, until you make that transition. But I do want to, lead us into our next webinar here. So for everybody that will be joining, we're going to get a little bit away from the living trust side. I heard you mention probate a lot. So I do want to, leave us with, my spouse just died without a will. Now what do I do? So thank you everybody for joining. Hope to see you all next week. And thank you, Dave.
Absolutely. Thanks for having me.